Good morning, everyone. Good morning. I'm just going to put my number in here while you guys are tuning in. We've got a lot to discuss today. Hope you guys had a good weekend. It's been a bit hectic for me. So I haven't been able to. My husband was burying his dad. We just lost my father-in-law, so it was burying him this weekend. And so I just couldn't get on here. I had to deal with that because that was obviously more important. So today I will be talking about the updates, but just give me a second, guys. Let me just put in this phone number on Instagram and then we can get started. Thank you very much. I appreciate it. 233. Thank you so much, Nalechi. I appreciate that. Okay, so thank you. It's really been a tough year for my family. Just a lot of loss and just some days, it takes the grace of God to deal with everything going on and in our personal lives and still come in here and have to take on people's problems and the administration's problems. So, but it is well, we trust God and, he lived a full life, 85 years. So we're very grateful for that. So today, first of all, if this is your first time tuning in, welcome. My name is Aisha Chidoli. I'm an immigration attorney here in the United States. My office is in Atlanta, Georgia, but I represent clients all over the United States. Our phone number, we have a few phone numbers, which I've pinned over here. It's 678-325-1037. or 678-233-2170 to schedule a consultation. You can also schedule a consultation directly on our website by going to chidolwaylaw.com and click schedule a consultation. Finally, you can also send a WhatsApp message if you want to book a consultation, but for whatever reason, you can do it online, or call. It's 404-333-8751. That's our WhatsApp phone number. Okay, guys, so I want to talk about the memo, whether you can still adjust your status in the United States and what all of this means. I'm sure you guys got the memo, and I got a lot of, tea and stuff for you guys. So let's first of all talk about what is adjustment of status. So for those of you who don't know, adjustment of status basically is the I-485 form. That is an application that allows you to adjust your status while you're in the United States. So some people, become green card holders from outside the United States where they consular process into the United States. And some people are already in the United States and they file for adjustment of status. The rules typically are that if you are married to a U.S. citizen or you are the parent of a U.S. citizen who is over the age of 21, or if you're the child of a U.S. citizen and you're under 21, you're typically in what we call an immediate family category, which allows you to adjust your status even if you have overstayed or worked without inspection. I mean, barring certain other things like, fraud, misrepresentation that, they can either approve or not, or deny you on the basis of, or, false claims, barring other things, basically. And, just to be clear, USCIS officers have always had the discretion to look at an application and make a decision based on the application. So last week, Friday, a memo was released basically saying that now you're only going to be able to adjust your status. Well, let me correct myself. The title says you're only going to be able to adjust your status if you can prove extraordinary circumstances. However, the memo states something slightly different. It's basically stating to the officers and reminding the officers that they have the discretion to make favorable decisions based on negative and positive factors of each applicant. So what does that mean in layman's terms? In layman's terms, it basically means that they have to look at the application holistically and ask themselves, why should that person be adjusted in the United States versus consular processing? What are the positive factors and negative factors? I will talk about who this policy affects, who it doesn't affect. So there's a lot to talk about. So trust me, I wrote everything down. So I'll get to as many of them as I want. But first thing I want to say is, you guys have heard me, like even from 2024 during the election, I have talked ad nauseum about the wealth test. I have talked about this was what it was in President Trump 1.0, where there was a wealth test, we call that a public charge rule then. You had to meet the 7 categories or whatever it is. I was able to obtain 2 different RFEs from people who have received requests for evidence to kind of give you guys an idea of what it is that they're going to want to start to see from you when you put in your application. So now this is not a time to just let's just put in some paperwork, put some phone bills, put some whatever it is, and we're going to submit it. If you do remember, in the previous Trump administration, you had to meet certain requirements to get a favorable discretion. You had to show pros and cons. So essentially, this is almost very similar to it. But the language or the title has made it as such to discourage and to terrorize and to terrify people, from putting in their application. So the question is not whether you put in your application. The question now is whether or not, you have positive equities that weigh in the favor of you being here. So first, let me talk about who this policy affects. This policy affects those who entered into the United States with inspection. So with inspection, or you were admitted and paroled into the United States. So think about people who came here on an F1 student visa, people who came here on a J1, L1, O1, B1, B2, those types of visas, okay? This policy does not affect people who fall under humanitarian categories. So it's not going to apply to people who filed for, who have an approved asylum case that are filing for adjustment of status, an approved VAWA case who are filing for an adjustment of status, it's approved T visa case who are filing for an adjustment of status, or an approved U visa case, and any other humanitarian-based cases. So this is not going to be for you. I want those who have immediate family-based cases, which I want to say are the majority, of the people. Again, these lives, I do them for my audience. I don't handle business cases or employment, so I'm not really going to talk about that, even though you all fall under that. But I'm specifically going to talk about those who have family cases. Someone is asking me the pending asylum cases who are doing AOS. I literally just said that right now. It doesn't apply to humanitarian-based cases. So if you're adjusting under humanitarian-based cases, this does not apply to you. Humanitarian-based cases are T visa cases, U visa cases, VAWA cases, asylum cases, and cases like that. And also, it does not apply to those who came here on a K1 visa, because literally that's the intention, for you to come in on a K1 visa and adjust your status. So you're also exempt from it. It also does not apply to people who have 2-year conditional green cards, because you have already adjusted your status. Just keep in mind, if you don't remember anything else, this applies only to people who do not have any green card at all, who came in here with inspection, came on a tourist visa, came on a temporary visa like F1 or whatever it is. So hope that is clear to you guys, okay? Here's what, does it apply to those waiting for an interview? I would say you should be very prepared. Whether or not you have an interview, or you don't have an interview, you've already has your interview. It applies to everybody. It does not separate whether you applied before. And I will tell you what some of the RFEs look like. So here's one of the RFEs. Again, remember what I told you guys about the well test. When we tell you guys that immigration, it's moving at such a fast pace in changes, or to the point where even for USCIS officers, they themselves are confused, let alone like applicants, and attorneys. So when you qualify for something, for those of you dilly-dallying, thinking somehow things will change that will make it better for you, or a different administration, because you don't know what the next administration is going to look like or who the next administration is. You have to schedule your consult, determine whether you're eligible for something, and then make a decision based on that. So this is what the RFE says. This is one of the RFEs. Basically, the RFE is basically saying that in order for us to give you favorable discretion, meaning what are the positives? These are the positive factors that you've given, for example. Number 1, family ties in the United States. Do you have any family ties in the United States? Have you been a resident of long duration in the United States? So especially for those who have been residents at a younger age. So that's a positive factor. They also ask number 3, hardship to the applicant or to the applicant's family if relief is not granted. I specifically want to talk about this because this applies to a lot of people on my live. Immediately, because immediately, obviously I'm a lawyer, and I think everybody that's a lawyer is also immediately, I'm like, what are the hardships to my clients? Most of my clients come from the 75 countries with pauses and bans. That is an incredible hardship. That is an incredible hardship because the memo specifically says, if consular processing is available, why should we allow you to adjust your status? Majority of you don't have consular processing available to you because there is a ban or there is a pause. So that is a high positive factor, to argue in your case of extraordinary hardship. So keep that in mind. So those of you that want to be discouraged, keep that in mind. That is a positive for once, something positive that weighs in your favor. Next, we want to look at, again, under hardship, for a lot of people, and I don't know if you guys know this, if you've been in the United States for more than, like you came on a tourist visa or a temporary visa and you overstayed for more than 6 months, you have a 3-year ban outside of the United States, okay? If you've been here for more than a year, if you go back to go outside of the United States, then you have a 10-year ban. So let me repeat that again. If you've overstayed your time for more than 6 months and you leave the country, you have a 3-year ban from coming back into the United States. If it's been more than a year, you have a 10-year ban. That is extraordinary hardship because to say to someone who, i.e. maybe they've been waiting to file their case or whatever it is, so they've been out of their home country or they've been in the United States for more than a year, that's a 10-year ban. That's a 10-year bar, which separating family and children, that is extraordinary hardship. So that is a hardship that should be argued immediately, okay? Again, let's even say you're not one of those and you have, you have maybe not overstayed or whatever it is, and you can still show hardship based on your consulate. So like, let's say you've not overstayed your time or whatever it is, but you have a consulate where, there's a bar or a ban. Those are arguments that you should be able to make. Okay. There was one more hardship argument that I wanted to talk about. These are just the basics. Obviously, if you're a client, we'll go into depth on a case-by-case basis to determine what hardships there are to you. Okay, so let me continue. Number 4, they're asking for education. This is something that was in the previous well test. Your education level. What are you bringing to the United States? The USCIS spokesperson, after a lot of opposition came on Friday, came back and did some clarification and basically said, we basically are looking for people who provide an economic benefit to the United States, right? So they're looking at your history of employment, your fluency and proficiency of English, of the English language. Again, this was in the previous Trump 1.0 well test, and again, I know that I keep saying this, but it bears repeating because I talked about this, saying, because something is available to you today doesn't mean it's going to be available tomorrow. Like, apply and get your stuff situated before they make things harder. But sometimes, people think, most of you know, I'm not someone that comes on here to try to be an alarmist or to create terror or in an already stressful environment. Shoot, I'm dealing with stress of my own personal life, but, when we tell you something, we're telling based on the writing on the wall and what it is we see, okay? Another category is, another question or whatever it is that they're looking for is service in the United States, in the United States Armed Forces. Some of you might ask, if you don't have a green card, when did you serve in the United States? There was a time where certain people, based on language skill or medical skills, were allowed, into that. So those would be those people in those categories. They're also looking at the existence of business or property ties in the United States. Okay, these are all positive factors that you can consider. And then they're also looking at evidence of value and service to the community, i.e. religious organizations, volunteer organizations, and things like that. So if you are not volunteering, if you are not, basically using your time to show good moral character and being useful in the community, start now because it helps your case, okay? History of paying taxes. So if you're not paying taxes and you're able to pay taxes through an ITIN, pay your taxes. Pay your taxes. Stop trying to circumvent the process. If you have a criminal record, we need proof of rehabilitation and any other evidence demonstrating that a favorable exercise of discretion is warranted in your case. Okay, so the other thing that I specifically say is this, and which is why, again, this has a lot to do with economics. Someone asked, how are you doing business when you have no social security number? That is a good question. And as a business attorney as well, even though I don't do much business cases, but my background is in mergers and acquisition and intellectual property and business, small businesses, you can do business without your social security when you set up your organization, because you're getting an EIN number for the organization. And as a member of the business, you can get an ITIN. So you don't need a social security number to do the business, just as an FYI. And yes, an SSN might disqualify you for doing almost everything, but not necessarily. I'll go over the ones that it doesn't disqualify you from, because again, I'm a solutions person. So instead of what is the problem, how can we resolve it and make sure that you are a viable candidate? And then it goes on to section 2, where it says, in order to be eligible for adjustment of status, you must demonstrate that you are not likely to become a public charge. Therefore, please provide proof of your income. And it might include things like your income tax, a letter from your employer, bank statements, W-2s, or any other evidence you wish to provide. Understand that everything here, not everyone is going to have it. As you said, some people don't have a job. Some people cannot find someone to hire them if they don't have a social security number, because it is a risk basically hiring somebody under the table, but remember, there are also categories of people here who have this, who either have an SSN, who either are here on an F1, who either are here on an O1, J1, H1 that have this thing. So for those people, those are the people they're probably talking to in regards to this. Okay. So again, you had mentioned that, a lot of, it includes everyone. Someone is asking, does it include children under 18 years old? It includes everyone. Okay. It includes everyone. Someone is saying, I have an ITN and I stopped paying when he came in because of what I was hearing. Should I start paying it again? Absolutely. You should absolutely be paying taxes, because these are equities in your favor. Even if, God forbid, you were sent into removal proceeding and you want to show that you're a person of good moral character. These are some of the things that we're going to show. Look, this person has been here. This person is contributing all these things to taxes, but they're never going to have the ability to even get Social Security or Medicare, or everything else that people contribute. So basically, they're contributing to the economic benefit of the United States. So you should absolutely, if you can, still be filing, because again, there is so much noise, and I understand, the stress of it. But please, before you stop doing stuff or making drastic decisions that can affect or impact your life, make sure you are speaking with a competent attorney, who handles immigration laws, on cases that can answer your question. Someone is asking again, can VAWA still work? I said it in the beginning, I said it in the middle. Again, these rules do not apply to humanitarian-based cases. The memo specifically says we want to free up our time and focus on humanitarian-based cases. So trafficking cases where there's an approved, trafficking cases where it's been approved, U-visa case where it's been approved, VAWA cases where it's been approved, which is asylum cases that's been approved, those cases can adjust in the United States. Now, what, for me and what stance we are taking, the stance that we are taking here at this firm is ensuring that all our clients, even those who already have submitted, that we're going in equipped. So, if you are, part of this firm, we got you. We're not going to that interview without our list of things that make each client positively, that has positive favors in their favor. So, again, if you want to speak with an attorney, please call our office 678-325-1037 or 678-233-2170. You can also go on our website and put in your request or schedule a consultation there yourself. It's chidolelaw.com. Someone says, are N-400 applications still valid in current times? Absolutely. I mean, are you kidding me? An N-400 means that you become a U.S. citizen, and there is no greater benefit than becoming a U.S. citizen. I mean, it's extraordinarily rare. No matter what they tell you on the news, like imagine all the naturalized people in the United States, but yet only 12 people are going through a denaturalization case of the millions and millions and hundreds of millions of people here in the United States. So that is that should tell you that you should, if you are eligible for citizenship, that is the best protection that you can have. Now, in order to file for citizenship, understand that they will be reviewing all your applications. So you want to make sure that every application you've submitted was a valid application, a legitimate application, you basically are getting there in good faith. People are asking me on here, can you explain the new USCIS memo? That's literally what I've been talking about, but I'm going to assume that you just tune in. If you're just tuning in, I will save this live. It's going to be on my Facebook, YouTube, and Instagram. You can go back and rewatch it because that's literally what this live is about, okay? The other thing, because I told you that I had two different officer questionnaire, just to give you an idea. So like another group, this one was basically asked directly in an interview. The person was asked, why did you apply for adjustment of status instead of consular processing? Are there any factors that will prevent you from pursuing consular processing? Again, this number 2 is very critical, especially to those who belong to the 75 countries. If you belong to the 75 countries, one of the biggest and most critical factor that prevents you from that is because there is a visa pause, right, on you being able to consular process. Number 2, you are from a 39 country ban. So that prevents you, again, from consular processing. And then also look at and be able to explain the fact that you may have overstayed a year, more than a year after your I-94 expired. That gives you a 10-year bar. So that is extreme hardship. Again, you have to be able to articulate what the factors are going into this interviews. You have to be able to articulate in your applications. One of the things that, like I was telling my staff, especially my staff members who were not here in the previous administration, that's Trump 1.0, that ended in January of 2020. During that time, we used to have a section, because that time what they did was it was a specific form called the I-914 form. And that's where we did the positives and all the negatives. My goal and all y'all's goals when you were submitting those marriage-based petitions for green card is to ensure that your positive factors outweigh. So some of the things that we'll be looking at is country condition, country hardship, ability to rehabilitate. There's just so much, that I can't go into it. Obviously my own brains just start to think about the arguments that we should be making for our clients and questions we should be asking our clients to help support their case. Obviously, so in saying that, should you still adjust your status? You should absolutely adjust your status, but be prepared to support why you should do it here. Because for many of you, you have equities in favor of you doing it here. Now, if you have, the negatives, typically, I would say for most average clients already out the bat, there are going to be 2 negatives that you're going to see majority of people having already. The 2 negatives are going to be that they overstayed their status, and oh my gosh, I completely neglected Facebook and YouTube for the questions. I'll come back to that. The 2 negative factors are going to be that you overstayed your I-94, and for many people that they worked under the table. So your goal is to consistently have positives that outweigh that, and I want to go back because someone had mentioned that a lot of the things that they're looking for, you need to have a Social Security to do it, right? On the contrary, not necessarily, right? For instance, you're able to volunteer, you're able to be a strong member of your community without having a Social Security number. If you are a person that has a place of worship, go and find a way to volunteer. My husband used to work as the what they call the traffic wards, like in the parking lot in the church ministry, right? So you can do something like that. You can find ways to partake in your church. You can find ways to volunteer in volunteer organizations. There's so many, depending on where you're from and how you can provide impact, in some capacity, right? If you have an ITIN, there are other things that you can do with your ITIN, right? So again, all is not lost, but what I can tell you now, and what we've been telling you now, is that it is, people who think, sometimes we have people say, oh, I'm just going to marry someone, and just do it that way. It's going to be quick and easy. Nothing is quick and easy, in the United States. Nothing is quick and easy right now in the United States. And you just have to prepare in the state that you are, not what is going to be in the future, because you don't know what's going to be in the future. You don't know what the next administration is going to be. You don't know if it's still going to be the same administration. So you should always prepare, just like we told a lot of people the last time to prepare. So my mouth hurts. I've been talking, for the last 30 minutes. So let me take some questions. Oh yeah. Someone says, Aisha, the people sharing links and numbers, your people. Oh yes, I should probably say that maybe they should log in as me. Yes, they are my staff members, because I knew that today was going to be really busy. So yes, it is chidowaylaw.com/booking. That's how you book a consult online, or the phone number. So they are my people, so you can trust them. Someone says this whole thing is mentally draining. Trust me, it is mentally draining. I get it. I am dealing with mentally draining things in my own personal life. I've had 2 really sad losses, as I mentioned, but I'm here and I'm moving. So it is, what do they say? It's not whenever I get on this live, I have like brain fog and remembering my quotes. It's really how you react to obstacles, right? Because at the end of the day, I don't talk a lot about my faith, but for those of you that may know me, personally, that I have a deep faith. I believe in Jesus Christ, as my Lord and Savior. And I believe that faith and fear cannot coexist. So you can either have faith and trust the process and know that, God will show you favor, and that you do everything that you need to do the right way, and trust and believe that God will show you favor, or you can choose fear. Those are your options. Last week I had posted the day, actually it was the night that, before, what am I saying, the night? It was the day of the announcement. One of our clients got her green card. She had a valid case, and she got her green card approved on May 21st, right? The day that this stuff came out. And she got her green card approved. And, one of the things I specifically remember about that client, because sometimes you meet those clients who just have such a faith and a trust that things will work out, that it's really refreshing. Because sometimes some of you come with, and it might not be intentional, it might be stress, but you come in with a bad energy, right? You come in with an energy that is negative. And when you come in with an energy that is negative, it affects you. So you have to come in with a positive outlook and say, you know what, this will work. This will work for me. Okay. Someone is asking, what happens with existing applications considering the new adjustment of status? It seems that you might have just joined my live, so I'm not going to repeat it, start all over again. That is literally what this whole meeting is about, and I talked about it there, okay? All right, someone says, y'all need to trust Aisha's work ethics. I'm telling you, she's the best lawyer out there. She did me a favor by saving my husband from being denied in the US. Oh, yay. I'm so happy to hear, Deja. Love to hear positive impacts. It's still kind of sticky when you get to live in job doing 6 days a week. I'm not sure I understand the question that you're asking. Someone, Abe Tevolisa, is saying, you think I should get an attorney? You should absolutely get an attorney. Like, seriously, like if you're even thinking about doing this by yourself, not knowing what is going on in USCIS, good luck to you. Now, are people able to still do this by themselves? Absolutely. It's a free country. You don't have to use an attorney. But why put yourself through the process right, of building instead of hiring someone that's an expert, you know, or is capable of doing it and has been doing it and knows what it is that USCIS is looking for. It's like I can watch a YouTube video and learn how to build this desk that I'm sitting on. But no, I don't want to build this desk. I want someone who can build it in such a way that I know is not going to fall on top of my laps while I'm sitting here. So that is how you have to look at it. This is your life. You know, being able to be a green card holder or naturalized changes not only your life, it changes the trajectory of so many people's lives. Right? So the impact is immediate. And because the impact is immediate, it is very, very critical that you want to make sure that you are using someone competent that can guide you in the process. Okay. All right, let's see what other questions. I'll take one more question and I got to jump off. Someone is saying, if you came through a B1, B2 and you adjusted through marriage, but did not get a green card and they did vow, does this apply to them while still waiting for vow approval? No. Again, as I've said about 4 times now, and I'll say it again, this does not apply to those who have humanitarian cases that have been approved. If your humanitarian case has been approved, you already have established hardship, because a lot of these humanitarian cases have a lot to do with hardship. Right now, anyone submitting an application should be beefing up their application with those hardship arguments. Again, this is something that we will be doing for our clients. We've done it before, so we're ready to do it again. You know, I'm sure there's some people that were in that administration that may be on my live that can attest to it. You know, back then when people had to do the well test, had to prove this, prove that, but we were knocking it out of the park then. And by the grace of God, we'll continue to do that. I gotta go. But again, if you want to specifically talk about your case, because hardship and determining positive and negative factors has a lot to do with each individual. Not everybody has the same circumstance. You know, I have given you guys at least 2 arguments that you should be making for hardship if you belong to the 39 country ban and the 75 country ban, amongst other things. Please schedule a consultation. All right, guys. I will talk to you guys later. Have a good one. Bye.